Good afternoon. A few people are still linking up, so we'll wait a couple seconds to get proceedings underway. Welcome to the Sub-Saharan chapter of the inaugural Africa Construction Law Week. I am Michelle Porter-Wright, counsel in Allen & Overy's dispute resolution team based in Johannesburg. I serve also as South Africa country representative here at Africa Construction Law. This afternoon's seminar is a component of a 5-part virtual conference entitled Demystifying Construction Law in Africa, in which we seek to explore issues facing construction industries across the continent. The objective is to provide a tour of practice points and topical commercial issues facing lawyers, corporates, governments, and technical experts operating in their respective regions. We have had a fantastic series of seminars thus far, with the Lusophone and North Africa sessions concluding tomorrow, 15 April. Please do sign up for those if of interest. A brief bit about Africa Construction Law for those unfamiliar. The initiative seeks as a core objective to promote thought leadership in the construction law space on the continent, in particular in contributing to the development of law and policy, including as to dispute avoidance and alternative dispute resolution. The forum also seeks to showcase and develop Africa's legal and technical expertise in this field. Statistics show that Africa is an exporter of construction legal work, particularly for disputes. For example, African practitioners remain substantially underrepresented relative to overall African caseloads in international forums such as the ICC. Construction obviously is a core economic sector for growth on the continent, so we expect demand for these skills to increase in the coming years. Lastly, the organization has an empirical and an academic focus, collates data, conducts research and comparative reviews as to the state of construction law across the continent. The leadership structure and further details are available on ACL's website. If you'd like to be part of ACL's initiatives, may I encourage you to reach out and join through the membership portal on the ACL website. I must stress at this point that it is not exclusively for lawyers. You are eligible for membership if you're interested or professionally involved in construction in any capacity. Please feel welcome to join. Some housekeeping points. Today's seminar is roughly 3 hours, and I hope the catering is up to scratch where you're at. We have a great lineup of speakers from across the region, representing some diverse industry sectors. Botswana, Zambia, Zimbabwe, and South Africa are represented in our panelist profile. The first panel session will deal with practice points in project development and project finance. That session is 45 minutes plus 15 minutes for Q&A and will be moderated by A&O projects lawyer Pravesh Lalla. There will be a short comfort break between the sessions of around 10 minutes. The second session, which is the longer session of the afternoon, will look at regional practices in dispute resolution. That session is 90 minutes plus around 10 minutes for Q&A, and that session will be moderated by Robert Gatescale QC from Keating Chambers in London. Thereafter, and to wrap up, we will have closing remarks from ACL Director Dr. Ademola Bam Bose. Ademola practices in the International Arbitration team at Hogan Lovells in London. Please use the Q&A function to ask questions, although an upfront caveat, We have almost 400 registrations for today's event, so it's possible we will not get to all the questions. Please feel free to pop me an email with any unanswered questions, and I will redirect those for response. I will leave the moderators to introduce the panelists, but on behalf of ACL, I'd like to extend a special thank you to Pravesh and Robert for moderating our 2 sessions today, and of course to their teams behind the scenes who have made today's event possible. Thank you also to our other collaborating organizations, including HKA and Musa Dudia. Your tireless efforts are much appreciated. Enjoy today's event. Before we hand over to Pravesh to get proceedings underway on panel session 1, a few words from my colleague, A&O's Head of Litigation in Johannesburg, partner Gerard Rudolph.
Thank you, Michelle. So the latest report by Deloitte on construction trends in Africa for 2020 tracks 385 projects across the continent with a cumulative value of just short of $400 billion for the year. This is to some degree due to the COVID pandemic and is down from 2019, where the corresponding report tracked 452 projects with a cumulative value just short of $500 billion. And general expectations are that that the next financial year is likely to bounce back as the continent recovers from the pandemic. Now that's a fairly substantial amount and quite a substantial number of projects that are happening right across the continent. And as we all know, these projects account on an annual basis for a substantial portion of the much needed foreign direct investment received across Africa. But the reality is, in most instances, that while these projects create jobs and opportunities locally, the highest value portion of the total project costs typically spent is on imported materials, plant and equipment, as well as the engagement of international professional consultants, which includes lawyers, but also specialized contractors who execute the project works. Now, this is not by design or intent on the part of the project employers or funders, particularly where governments and DFIs are involved, but an inevitable consequence of a lack of local manufacturing and supply capacity, as well as industry skills shortages coupled to regulatory and customs barriers that often make it very difficult to promote trade and professional services across the continent. Hopefully, initiatives like the Africa Continental Free Trade Area will drive greater levels of localized manufacturing, procurement, and professional engagement across the continent. Additionally, one would hope that these initiatives will also drive greater collaboration between legal professionals in the construction and infrastructure space across the continent going forward. In this particular context, I hope you benefit from this conference, not only in the substance of the presentation, but also from a virtual networking perspective. On that note, I'd like to hand over to my colleague, Pravesh Lava, who will moderate the first panel discussion on trends and practice points in project development and finance. Thank you.
Thank you very much, Michelle and Gerhard, for the opening remarks. So we'll move on now to the discussion on project development and some of the opportunities and risks that are facing the operators in the region at the moment. For doing that, I would like to introduce the speakers that we have for this panel. So Sue Brighton, who is a senior partner at Gill, Goddilton and Gerrans in Zimbabwe. Sue has been a senior partner for about 30 years. She has a wealth of experience relating to a wide range of transactions, particularly relating to infrastructure. We also have Uwe Putlitz, who is a consultant at Building Strategy Property Limited, where he assists clients and contractors to avoid disputes in construction contracts. In 2019, he retired from the role of CEO at the Joint Building Contracts Committee, NPC. We are also joined by Talenta Chavala, who is a junior member at Group 1 Advocates, and his practice and interest is on general commercial litigation, tax law, banking and finance law, and also construction law. Talenta joined the bar after spending about 10 years as an in-house counsel. We are also joined by Nathaniel Enika, who is the Chief Investment Officer at Northside Finance Limited. And Nathaniel, prior to transitioning into investment banking, practiced as an engineer. Muchinda Muma is joining us from Moira Mukuka Legal Practitioners in Zambia. Muchinda is a senior associate who has considerable experience in large-scale energy, mining, infrastructure, and transport projects. And I am Pravesh Lala. I'm an associate with Allen & Overy, and I focus on projects and project financing in Africa. So the first discussion point that we'd like to cover is an overview of the contracting landscape and the risks and opportunities involved for the various parties in the region to set the scene for the discussion today. We can start to talk about the macroeconomic overview, especially the impact of COVID, opportunities for contractors, and major risks that are worth discussing. I'll next start in terms of what we see at ANO in recent times. And understandably, since the emergence of the COVID-19 pandemic, there was an initial significant concern from various operators in the region about the impact of COVID-19 on their projects in the pipeline and also operating projects. What we've seen in the most recent couple of months is that there has been a degree of reassurance that has reappeared in the market, and certainly a desire now to kickstart investments and projects which were put on the slow burner for some time to accelerate their progression either towards financial close or to becoming fully operational again. So quite a busy time on the projects that we are advising on. And more generally in the market, we are seeing a resurgence of activity, notably with some cautiousness still a significant amount of interest from development banks, project developers, contractors as well, to starting to get involved again in significant projects. Sue, maybe this is a good time to pass on the mic to you. What are you seeing in Zimbabwe at the moment?
Thank you very much. Zimbabwe major economic impact on the country. If anything, the impact on the country during the COVID period has been far more that of the currency manipulation undertaken by government. So the attitude in Zimbabwe, and this reflects directly to developers across all sectors, is that there's a very positive approach in trying to make things work. And we have seen considerable investment in the construction industry, although on a very small scale, during the course of the last 12 months. And I'll come back to that later, if I may, relating to currency risk and investment in Zimbabwe. But suffice to say that at the moment, if you drive around the capital, you will find bricks, cement, and sand on the pavements waiting to be used. So there's a definite uplift in construction activity.
Thanks very much, Hugh. Nathaniel, do you have any insight in relation to the project that you're working on, or with a particular jurisdictional perspective?
Thank you, Pravesh, and good afternoon, everyone. Indeed, Nosat Finance, we are domiciled in Botswana, but undertake regional work in terms of financing projects within Southern Africa. Before I jump into what would have occurred at the advent of COVID, there was, as you pointed out, significant traction prior to 2019. There was an air of positivity within the region and in specific countries, quite a lot of projects coming up. But obviously COVID-19, the first phase was involved hard lockdowns, which means no one could actually do anything. And after the hard lockdowns, there was kind of this tentative stage where people were maybe not so sure whether they should proceed with their projects or abandon them in total, or do them in kind of a slow burn rate, which you did allude to. We are starting to see some projects, resuming, but it's still been quite slow. And I'll just give one piece of evidence maybe to just support that. Let's say somebody was constructing a hotel at one point, and it doesn't matter that the construction industry is now open. It's quite hard to just achieve 5% occupancy. So then that person is not so eager to kind of accelerate and then complete that project. So this is kind of 50-50 split that we're starting to see. Some projects are taking off, but they're still a bit slower than they would have been.
Thanks, Nathaniel. Yeah, I think that's very interesting, actually. And we are seeing significant activity in the energy sector, including for the new pipeline projects that are coming up. I think, like you mentioned, it is because the countries will still need to resolve their energy deficiency issues, and that is there notwithstanding COVID. In terms of the infrastructure sectors in which we've seen some more constant and more heated up activity, we have a significant ports project in Nigeria that we worked on recently that pretty much carried on as normal. And what was interesting for that project was the significant involvement of developers and contractors from China, actually. And so it was interesting to see how on certain infrastructure projects, the activity was somewhat maintained. From the jurisdictions that you've been operating in, Nathaniel, are there any upcoming interesting energy programs which you see is being implemented on an accelerated basis, or some more specific infrastructure sectors that are having a bit more attention at the moment?
So as you have pointed out, because Africa continues its journey towards achieving development, some infrastructure, especially around hard infrastructure, inevitably is required sooner or later, be it a pipeline, an airport, a port, or look at Mozambique, for example, the whole gas project. It's unfortunate a few, sad events have occurred in recent times, but such projects, we have seen them being required and going on quite strongly. Countries like Tanzania, for example, have actually seen a significant infrastructure program. With respect to energy, we've seen both small-scale, large-scale energy projects, but more specifically, the renewable energy IPP program in South Africa and even outside South Africa has become quite significant. Southern Africa suddenly realized that we've got lots of sunshine, and solar is quite inevitably a reliable energy source that we could use in this region. So we have seen, be it at Zimbabwe, Zambia, Botswana itself, Namibia, different forms, be it hydro, solar, wind, starting to come into the mix as the energy mix gets diluted and starts drifting away from coal. So it's been quite a significant moment for infrastructure, both hard and soft.
Thanks, Daniel. And Sue, do you see any interesting opportunities coming up for project developers in the region from your perspective?
There's a great deal of interest from the various IPP developers, and there are a number of generation licenses that have been granted to developers who are looking for support. So at the moment, there are successful solar projects, there's successful small hydro projects. There are, as I'd say, a number of developers looking to progress with bigger solar projects. The most viable of those are the solar projects to support the mines. There are large projects being considered for mines, 150 to 300 megawatt. Mines will be ring-fenced off-takers, potentially using the grid as a battery backup overnight, thinking effectively of using the water storage in Kariba as a battery. So those have a good chance of progressing because the demand is there and the mines need the reliable power support. And of course, Batoka remains of considerable interest. There's various parts of that project being worked on at the moment. And if that can go ahead, it will help the region substantially.
Thank you. Thanks a lot, Sue. I think moving on now to some of the major risks for operators in the region at the moment. I think, Sue, you've mentioned some of the constraints in terms of currency conversion and access to foreign currency at the moment. We're seeing some more long-term issues that remain to be resolved on projects that we advise on, off-taker creditworthiness, addressing political risk. Another interesting theme is the relationship between local contractors and foreign contractors and local requirements through the, for example, the Get Fit program and the scaling solar programs, that there is a significant amount of local involvement, but there is a friction in terms of the expertise from local operators also being up to a certain international standard. What are the issues and risks that you're seeing for both project developers and contractors in the jurisdictions you're operating in? So maybe you can start first.
Thanks, Prav. Addressing the points you've raised, Zimbabwe now has no indigenization requirement. So we've gone the full circle. We've gone from a mandatory 51% indigenization requirement to now virtually no indigenization requirement. The only local content or indigenization requirement is in the platinum sector and sector, although as we speak today, that requirement doesn't apply. So Zimbabwe is well aware it does not have the capacity to run any projects. The projects are run out of South Africa, or they are entirely Chinese run. Kariba was done by the Chinese, Wangi was done by the Chinese, and arguably Batoka will be done by the Chinese. Our biggest risk and our biggest issue relates to our currency, our manipulation of the currency, and the lack of credibility in respect of currency. Added to that is the issue relating to land tenure, and land tenure speaks directly to the large solar projects, which is another reason why the solar projects for the mining companies tend to be a better bet, because one has land tenure through mining title. The good news is that Zimbabwe is more positive in its interaction with the real world. So we are being able to make progress in trying to get better land tenure and trying to get some currency stability. And we certainly have far greater currency stability than we had a year ago. So it's positive. There are ways of structuring transactions, but certainly transactions have to be carefully structured around those two items.
I'll just add in terms of the risks we see in our region, specifically, as NOSAD, we tend to finance multiple jurisdictions, hence the currency effect is inherent. But what we have actually done is when we are financing projects, some of the key elements in terms of the success, because we look at it from a financing point of view, and if nothing goes right, The challenge is that we might have to restructure or eventually write down a potential investment, and usually it's a self-feeding cycle where a project is delayed, then it requires more money, more capital is required, and then maybe it might even get commercial irrelevance somewhere along the way. So some of the things we always look at as financiers is to look at, can we have like the likes of cost overrun guarantees? Can we look at sovereign guarantees or sovereign-backed third-party guarantees that can actually unlock the potential in projects? We don't look at it as political, because I think our region is just political one way or the other, and it's quite hard to underwrite what kind of politics you're actually underwriting in that context. But we can look at it as non-performance, maybe due to harsh movement in currencies or something goes wrong, and the government will have gotten a guarantee to actually underwrite that. Some of the other key elements we look at is when companies are engaging in EPC contractors, they use credible EPC contractors who are able to deliver that with, while I'm not a lawyer, we'll make sure that such agreements make provisions for what happens when you have an overrun in terms of time or in terms of cost or in terms of delivery for that matter. So those are some of the matters we actually look at as a financier.
Excellent, thank you, Nathaniel and Sue. And just a reminder to the attendees that you can drop us questions if ever you would like to raise anything. We want this to be quite an interactive experience. I'll move on now to the second discussion point, which is looking in more granular detail at some of the key negotiation points for contracts in the construction space. Muchinda, Uwe, and Talenta are going to talk to us about their experience of how recent events are affecting those discussions. In particular, I think what would be interesting, or what are the key issues that both employers and contractors seem to be particularly nervous about at the moment, and issues that they do want to try and incorporate as high priority in their documentation. Maybe we can start with Muchinda, if you'd like to share some of your experience.
Thanks, Pravesh. What we see in terms of the sticky issues between employers and employees when negotiating contracts in the advent of the COVID era has been defined mostly by the risk profile of the contract. So we have seen more push from employers when it comes to provisions for timely completion of the project. So you will find that an employer, in trying to address the financial risk that timely completion presents, will try to put in as many protections as they can. And one of these would be liquidated damages clauses. So you will find a lot of push from employers to have a clause which specifically has a fixed amount for any delay in completion. It could be a weekly amount or a daily rate. Liquidated damages clauses on their own may not be sufficient, so employers will also push to have certain financial guarantees included in the contract. This can be in the form of performance bonds, and this could also be demanded from both the contractor and the subcontractor. So I think that's the kind of sticky issue that is presenting itself at the moment. Another point would be from the part of the contractor in trying to manage their risk of default. We see a lot of push to have a clear program for performance. So the contractor will want to make sure that they have a program that they can follow that will ensure completion of the project in a clear and timely manner. And to do this, what they will ask for normally is some form of advance payment to secure purchasing of materials and paying for labor and things like that. But what's also interesting and what has come up in the recent past is, especially in the private sector, you will find contractors who do not ask for an advance payment because they have enough money to put up front and develop the project to a certain stage. and then ask for payment at a later stage. So this obviously creates a very uncompetitive environment, especially in the local scene where most local contractors do not have that kind of financing. So I think these are the issues that we're seeing at the moment, especially in Zambia.
Okay, that's a very interesting point, actually. So, Talenta, do you want to also share some of your views on the issues you're seeing in contractual negotiations at the moment? I think you might be on mute there, Talenta.
Yeah, I realized that I was on mute, but I have since fixed that. So the point that I was raising, Pravesh, is that in any project for the construction of any facility, obviously the employer is more interested in seeing that that particular project is completed on time, within budget, and that that project or facility, it meets the contracted design specifications. So basically, and just like Muchinda has indicated, so what you'll see with employers is that they will want to put more effort in contracting to ensure that there is a proper completion support for that particular project. And the completion support basically will also go into issues to cover issues of cost overrun. Because I mean, you'll understand that employers will normally commit a predetermined amount basically to meet the construction cost. So whenever those amounts are drawn, so it becomes very difficult for the employer rather to fund construction cost. So what you'll find is that employers in contract negotiation will therefore want to push for a single point lump sum turnkey contract. And in this way, they will then be able to transfer the risk with regards to cost overruns to the employer. And also, on the other hand, that will also incentivize the contractor to make sure that they stick to the construction budget. They also, in order to avoid unnecessary delays. I think Muchinda also spoke about the issues relating to performance bonds that they'll also push for, together with things like guarantees. And I think, and especially in the South African context, you'll note that there's been a lot of litigation basically that were concerning guarantees. So it's very important. It's very important that the employers, in the negotiation of these contracts and ensuring that there are proper covers in the form of performance bonds and guarantees, that they eliminate any form of conditionality that may be attached to those performance bonds. Because the challenge with that is that at a time when you want to perfect those bonds or those guarantees, what you'll often encounter is that if there's a lot of conditionality, it then becomes very difficult for the employer basically to be able to get the remedy that they might be looking for. And one last aspect with regards to employers, and especially in the South African context, but I think this will apply also in other jurisdictions, the issue of procurement risk. The issue of procurement risk, in fact, this is more for the contractor as opposed to the employer, because the contractor must ensure that in the negotiation of any construction agreement, and when the award is given to them, they must try and sort of get some indemnities, basically to indemnify them against any challenges that may result wanting to challenge the award, basically, of that particular project. And I'll then recommend that in those negotiations, it will therefore be advisable that the contractor also seek that they are covered with respect to any litigation cost that they might incur.
Yeah, that's very interesting. Thank you, Talenta. Yue, maybe we can have your thoughts on that subject as well.
Good afternoon. Yes, thank you very much. If you work, whatever form of contracting you do, you need to make sure that you have a roadmap in your mind, that the employer knows what he or she would like to achieve and how you best get there, and what the final result is likely to be profitable, and that it becomes a win-win scenario for both parties. That says a lot in a very few words. But if you look at where disputes come from, it's very often that the project hasn't been defined properly in sufficient detail. This is where the employer presumably knows best, and maybe his consulting team doesn't know quite as well as they ought to. Or there's the other problem that we come across not infrequently, that the professional fees are cut to such an extent that the professional team can't do a proper job. But maybe that's a separate discussion. And depending on what the nature of this project is and where it's located, the form of contract that you ultimately sign and the other support documentation that goes with it, be bills of quantities, drawings, and all the rest of it, may vary from country to country. If we talk of the old Commonwealth countries that most of us are part of, although if you look at Mozambique and Angola that are in our region with the Lusophone traditions, which are a bit closer to the Francophone conditions, where certain other things apply. But those, for instance, are covered largely by the FEDIC document, but they're not covered too well by the English documents if NEC or JCT is used. And generally, JVCC is only used for building work rather than big civil engineering or infrastructure work. And simply because you need horses for courses. Not every contract covers all the eventualities, and some do it better, and some take a lot of words to say things which suspect that a lot of our audience are lawyers. You make money out of it because people don't understand some of the wording, which is where some of the younger contracts like NEC are actually very nice, because the wording is concise and short and it's easy to understand. So in a nutshell, you've got to know where you want to go to and how you're going to achieve it. And the challenge comes particularly that a lot of South African contractors, because there hasn't been that much work here, are working elsewhere in Africa where they don't understand the culture and how you deal with the local community. And although you might not have to have a significant local shareholding, although that helps, you still need to know who's who and who to talk to and how to get things done. And that also raises what one of the other speakers mentioned, getting materials. And depending on how you get them to that particular country, if you take the recent events, traveling by road from South Africa into Zimbabwe, where trucks have been standing at the border post for 2 or 3 weeks, and the same to some extent on the South African-Mozambique border, that of course puts a tremendous pressure on everybody to get a job done. So in a nutshell, we've got to know where we want to go to, we've got to have the right tools, we've got to find the right people and manage that process. And we need to try and anticipate a lot of these things at the beginning. After that, it's too late. So you've almost got to imagine the project as it is in the final stage, and you almost need to anticipate what could go wrong. And that is part of your risk management, to try and ameliorate that in your design decisions, in your procurement decisions, and then to make sure that the project is executed against those yardsticks.
Thanks very much. And there's a few themes I think that are coming out of your discussion points, which I think will be particularly insightful for the attendees. In terms, for example, of pressures on pricing, I think you've touched on that already, Yue. What are the current pressures that are either trying to force, from employers trying to force down contractors in terms of their pricing arrangements? Are there contractual arrangements that are being presented as alternatives, as being more cost effective for employers? And then how do you actually see those alternative contractual arrangements working out in practice?
By and large, there is not that much work around. So employers can, to some extent, pick and choose, whereas contractors must price very competitively to secure the work. And this is where experience and maybe having the resources is easier for the larger contractors to price competitively, which may sound counterproductive, seeing you've got more overheads, but generally they can go and offer a better deal than a smaller company that doesn't have the necessary resources. So at the moment, it's probably a buyer's market rather than a contractor's market, where there's plenty of work around and you can have a markup because one way or the other you'll do okay anyway.
Yes, thank you. And there's one question coming from the audience, and maybe that will be an interesting one for Talenta to share your views on. It's coming from Tandika, who says that there seems to be a large shift of risk to the contractors with respect to negotiating a contract during the pandemic or as a result of the pandemic. Which clauses are often affected regarding this risk, and how can the clauses be made fairer?
Thanks, Pravesh. I hope I'm audible. I think some of the clauses basically is that in contracts negotiation, what you may find is that the employer may want to have sort of a clause basically dealing with cash retention, and basically that is done in order for the employer obviously to protect themselves against the situation where you find that the contractor may not want to basically come and complete the project, and obviously also in those cash retention provisions, you basically want to motivate the contractor to come and complete both the defects as well as the outstanding works. And this basically usually will work as perfect security for the employer, because this is the cash that is already in the hands of the employer. But what you'll also see in that is that sometimes contractors may want to push back basically and rather have cash, rather retention bonds as opposed to cash retention, because with the retention bonds, at least they are able now to have a third party who basically come and guarantee that they will then come and either complete the project or attend to any defects that may have arisen out of the project. But with the cash retention, what you see is that it's more for the contractor to make sure that they've got proper and regular cash flows, as opposed to cash retention, where basically the employer is withholding some of the funds. And I'm not sure if that fully answered Tandeka on the question.
Thank you. I think that's a very, very insightful response. I think we can also touch upon the interaction between local players and foreign players. And Chinda, I think your insight for Zambia would be interesting here. We're aware, for example, and it's an interesting case study for the region, of a lot of participation by Chinese banks, Chinese contractors, and Chinese players generally in Zambia. How have you seen that relationship pan out in practice, whether it's amongst the contractors or with other important stakeholders in the market, such as the government of Zambia itself? I think it'd be interesting to have your insight on that.
Thanks, Pravesh. What we have seen is a local and foreign alliance that has resulted in both good and bad practices. So the issue really, in terms of where things are now, is difficult to pin down because of lack of industry reports in this regard. But what I can say is that a lot of the barriers that we saw to foreign players adhering to good practices that essentially result in, sustainable construction are still in existence. So there is a high cost to adapting to sustainable construction practices. This is very common even amongst the Chinese community or Chinese contractors, as you have pointed out. Another issue is lack of enforcement by the regulators. So they do put in place standards and requirements that must be adhered to by both foreign and local contractors. But even in the wake of bad practices, there's a lack of enforcement. So that interaction is really something that needs to be looked at. Another issue, which is a barrier to sustainable construction practices, is a lack of knowledge on the benefits of such practices, as well as a lack of green certification within the country. But we have also seen some progress in removing these barriers, and hopefully this should result in better practices amongst different communities of contractors here in Zambia. And one of them is in 2019, the Securities and Exchanges Commission here in Zambia issued the Green Bond Financing Guidelines, which basically should apply to issuers of debt or security instruments that are labeled as green. So this is supposed to encourage contractors or other sector players to develop their projects in such a way that it results in good practices for both the environment and the economy, but also that they adapt to sustainable construction practices. And there is a huge opportunity for financing here if a project can be adapted to these guidelines. One could ask, what if someone simply puts a label and says, we are carrying out good practices as foreign or local contractors? The green bond financing regulations have put in place sanctions for greenwashing, and hopefully these sanctions will be enforced by the local regulators. There was also a program by the government through the National Construction Council to implement and promote green jobs here in Zambia. And this was basically to raise awareness on the benefits of complying with such good practices. So hopefully with the steps that are being put in place, both regulatory and just from an industry perspective, we should begin to see some good practices amongst the different communities of contractors here in Zambia.
Pravesh.
Yes,
Mushinda,
go ahead, Toronto.
Yes, I think what I've also seen with regard to some of the difficulties that will normally involve, that will be experienced in a foreign and local alliance. And I'll just give an example. In projects that are funded by foreigners, or rather more the Chinese in this case, you find that they do bring their own employees into projects. So that may end up undermining the local contents requirements. And in some other instances, you may find that it also lead to some protest actions. And you know, in the South African context, we recently have, or there's this group of construction mafias that basically it's been reported widely. And with that, you may find that these guys might end up taking advantage of the situations. And another issue will be the issue of communications between, let's say, the Chinese contractors, and in one case, in Katu, in one of the solar project, I think it was a Spanish contractor. There were issues that basically ended up delaying the finalization of the project because there were a lot of issues with regard to communications. It was not easy for the locals basically to understand or take instructions from the contractor. And in other instances where you find that the EPC contractor as well as the supplier of some machinery, especially in technical project, you find that the operating manuals are basically written either in Spanish or they are written in Chinese. It therefore becomes very difficult for the locals or anyone basically coming from the locals to basically understand how to operate such project. So a lot of time might end up being taken basically in trying to translate those manuals. I've also seen instances where you find that in some projects that are run by the Chinese, the issues of health and safety, it's often not a priority, as well as the issues regarding working hours, and such may then become problematic, basically, especially in the South African context. You will note that if there's an incident in a mine that concerns safety, it may also lead to the closure of that mine. So within the South African context, I do know that the issue of safety becomes a very important issue, and the issue of working hours. So those are some of the things that you find that they do cause difficulties as well in alliances involving the locals as well as the foreign suppliers.
Yes, thank you, Talanta.
Can I just add something to money, please?
Yes, of course, please go ahead.
There's a fairly interesting development in South Africa that you can now go and use an escrow account. And it's an American idea initially, but it means you've got an outside source that manages the money. Lots of contractors complain that payment certificate is issued, but they don't actually get the money. And that applies particularly to the retention money that Mshina mentioned earlier. Whereas in this case, the money is now paid into a neutral body, being a bank in this case. And when the payment certificate is issued, that money is then released. So the employer has got to pay his money into the bank. And from that pool of money, the contractor is paid at the right time in terms of a payment certificate. It makes it more difficult for the employer to avoid making payments to the contractor. And that the contractor, of course, in all standard forms of contract, has still got the right to suspend the works if he doesn't get paid and has followed the procedure to give notice that he hasn't been paid. From what I hear, particularly from subcontractors, this escrow idea seems to be taking foot.
Thanks a lot, Wei. There's quite a few interesting questions that have come through in relation to the construction aspects that we've been discussing. So I'll raise a few now. So there's a question from Julian, who's asking, from a contractual perspective, is it the norm for infrastructure and other construction and engineering projects to be governed by standard forms of contracts, principally FIDIC? In your experience, are these heavily modified by bespoke amendments? Maybe you can share your views on that one.
I've got a strong view about modification to contracts, because invariably you change things that shouldn't be changed. It's usually more successful when legal practitioners do that. And in fact, in the guidelines to FIDIC, they say that it may be necessary, and they're happy to have that condoned, but they say then you need to use the language of the contract, the same sort of wording, that you don't get confusion between clauses, and that somebody who's competent must be able to check that you don't create any other form of conflict. You might be achieving exactly the opposite. The whole reason why there are standard forms of contract is that the users in the industry, be it the employers or the contractors or subcontractors and suppliers, know what is contained in that contract. It might be slightly one-sided depending on who the drafters of that particular document are, although all the common forms of contract have got a panel drafting them to try and balance the risk, and that it is reasonably allocated between the two parties. Of course, you can always go and write your own contract, but then the problem is nobody quite knows what's in it, what's not in it, what should be in it, what happens because something has been added or left out that should have been there. And you might actually find that you're spending more time to sort out the contractual problems than actually getting the work done. But the whole idea of standard form contracts is that because they're understood, that should be the easiest way of contracting for all concerned.
Pravesh, can I also come in on that point of whether standard contracts or whether you go bespoke agreement? What I've seen especially in large projects and more in the IPP space, I have seen in these contracts, and most of the contractors will be like foreign contractors. I've seen that they normally go for bespoke agreements where basically they start negotiating these agreements from scratch, and basically they are more comfortable in using this form of agreements. And of course, they do take some of the learnings, or rather some of the provisions that might be contained in some of these standard form agreements. But often you'll find that both from the employer side and the contractor side, they also have a strong team of lawyers on both sides that basically will be going through these agreements, and obviously a lot of time will be spent basically in the negotiations, and obviously talking to the points that in this session we're talking about, basically as to what each party is pushing for and the stuff. So I've seen that bespoke agreement, they normally work perfectly in these large projects.
Great, thank you both Uwe and Talenta for these insights, and being conscious of time as well. I think it would be interesting to elaborate a bit more on a few of the bankability points that we initially addressed with Sue and Nathaniel. And I think some of the key bankability concerns on projects at the moment. We spoke about political risk and how development banks and states are turning to innovative instruments to try to address these risks. What we've been seeing on our side in terms of the projects that we've been advising on is a move or an attempt to move away from the classic state guarantees to project developers, and a certain transition to put and call arrangements in relation to state obligations and termination compensation. We've also seen a lot of development institutions through the World Bank, the African Development Bank, and the Proparco and French Development Agency coming up with letter of credits and political risk guarantees, both to help address state political risk and also to a certain extent of taker creditworthiness in energy projects. Nathaniel, do you have any insight on these kind of instruments and how you've seen them work out in practice on projects you've been involved in?
So thanks, Pravesh. So you know, the sympathy on the lender is that, you know, while the employer and the contractor are in dispute, you know, we are standing on the sideline hoping we'll get paid one day when the project actually kicks off. And the pressure on the employer is that they still need to pay us because we've got a contract that says you finish this project in 24 months, and now it's you know, 48 months, and you're still dragging each other, and we are owed money. So if we have third-party guarantees, for example, that we can exercise on to exit us from such investments, these are some instruments that we'll be considering to see how can we exit this investment at this point, sell down the debt if potentially possible. But to mitigate some of those risks right up front is that we now use lenders' technical advisors. So instead of relying on the engineers and the contractors to be telling us what's happening in the project, we now have to incur further cost of somebody who actually goes and inspects this project on our behalf and actually gives us a heads up if there's a storm coming on the horizon.
Yeah, thanks a lot, and agree that's a very useful process. There's one question that has come from the audience for USU in relation to the land tenure risk that you've been encountering in projects in Zimbabwe. So Patrick is asking on what measures you've seen to address that risk in terms of risk mitigation strategy. And has the government's inability to give guarantees on those power projects had a general ripple effect on projects in Zimbabwe generally? And Patrick would also like to know how you've seen that political issue addressed in Zimbabwe.
Thanks, Prav. Yes, Patrick, the land issue in Zimbabwe. Government has made moves towards addressing the land problem. There's currently a land commission sitting, which is looking at giving back some genuine title. Government is also moving towards a bankable 99-year lease. They call it a joint venture agreement, but it's actually a 99-year lease. And they have been open to some realistic drafting of that. And we are looking at getting to a document, certainly as far as that lease goes, that is registrable and will give a fair level of title. The problem is that there's always a risk of land acquisition by a government. It's not unique to Zimbabwe, it's just that Zimbabwe has made a great song and dance about it. The risk of land acquisition is far less if you are looking at urban land or where there's mining title. And accordingly, for the power projects, wherever possible, we try and find urban land and we try and find land with mining title. And then one looks at getting a special economic zone declared for that power project that gives certain investor protection. So there are ways of doing it. I think the biggest issue that we see for contractors and lenders in Zimbabwe is that we're not actually a province of South Africa. And very often, most of the lenders are South African based. A lot of the construction entities are South African based. And when you're looking at the IPP developers, they have expertise in South Africa. We, on an almost daily basis, are advising entities that they did not obtain the necessary regulatory approvals that are peculiar to Zimbabwe. And I stressed again, Zimbabwe has some peculiarities. It feels like South Africa in many ways, but these peculiarities can upset the rights of lenders, contractors, and the IPP developers. So those need to be carefully addressed in the beginning. For instance, the put and call option. It's a great idea, but you need to get exchange control approval when you draft the agreement, not when you exercise the option. It's little things like that. The procurement legislation in Zimbabwe is now extensive. It's complex. It's a nasty piece of legislation to try and work through. But if one is dealing with any entity that may be regarded as being owned by government, and that includes a local council or municipality, you have to comply with that legislation. So we are very dependent on South Africa, and thank you to all those South Africans who keep the country going. We're very grateful, but one can't let a project be undermined by failure to look at the technical legal details in the beginning.
Absolutely. Yes,
I see there's a comment or a question regarding negotiating contracts rather than tendering. There's nothing wrong with negotiating a contract if you've got the right resources and the right skills. The whole reason for tendering is to see if you can get a more competitive price. And then, of course, you might go for the lowest price and find that the lowest price is so low that the contractor can't actually do the work for that amount of money. So that's a risk that you've got to take and be aware of if you go for the lowest price. It may be quite justified, very often it is, but there are quite a number of occasions where it's not. What's quite interesting is there's something that's often referred to as a Swiss system, that you get whatever number of tenders, sort out who actually qualifies, and then get down to the last 5 or 8, take the average and see who's the lowest or who's closest to the average, not the lowest. Then you're fairly sure to go and get a fair price that has got everything included without cutting corners, using less cement and second-grade tiles and so on.
Thank you, Iwe. So there's few questions that have come in, and potentially one that's interesting in the Zambian context, Muchinda. I think you might have touched already on some of the strategies to assist local Zambian contractors, but one question is, are there any policies to aid local contractors who might not have the capital muscle as foreign contractors might do, to undertake projects in Zambia without upfront payments?
Thanks, Pravesh. So the current policy that we have is 20% subcontracting policy by government. So for every project by foreign contractors, you are required to have 20% local subcontracting. This has been a policy for some time now, but we do have a new construction legislation that was enacted in November last year, which is likely to make this more of a mandatory requirement. What we see in terms of assistance for local contractors in coming up with advance payments, there really isn't much at play at the moment. So, and in fact, this is one of the biggest problems that we have, because the current requirements are that contractors should be registered, and registration is according to certain bands. So it's a numerical ranking. So you're ranked from number 1 to 6, and 6 being the lowest, 1 being the best. And in order to get this ranking, you need to prove that you have certain financial capacity, you have certain technical know-how, you have the skills required, and depending on that, you're upgraded. And so even when you are a local contractor trying to bid for certain works, you will be considered according to the band that you're in. So already from the beginning, you are disadvantaged, because most local contractors will be within band 3 to 6, which is like really low. And to get them to a higher band, they would need to show that they have, you know, those capacities like financial or technical skills. So it's really difficult to upgrade them. And what we have seen, I think, in some of the projects is that there will be deliberate, targeted effort to try and get local contractors certain skills or access to certain finances. But in terms of a deliberate effort by government, we don't see a policy in that regard at the moment. So it is something that really needs to be worked on.
Thanks a lot, Muchinda. And I think on that note, we'll wrap up the first panel discussion. I'd like to thank all the speakers that have joined us today for your insightful remarks. And thanks also to the attendees who submitted questions. Unfortunately, we couldn't go through all of them, but hope you have found this an interesting discussion. So I understand there's now a break, and then we will be back online in about 10 minutes for the second panel discussion. Thank you, everyone.
Good afternoon, everybody. It's a great pleasure to be here and to be chairing this very exciting session which we've got before us. Our session runs from now until an hour and 40 minutes away, 100 minutes. And in that time, we're going to be covering a huge span of exciting presentations, covering people who have in-depth expertise in all aspects of construction disputes throughout Africa, and indeed, in most cases, throughout the world. So we've got an exciting time ahead. What I'd like to do at this stage is to give you very quick introductions to the 9 speakers that you're going to have the pleasure of hearing. And you'll see that they're going to be speaking in 3 different groups, 3 particular panels. The first is to look at project stumbling blocks. And the 3 speakers there are going to be Abdul Janadu, Melissa Peter, and Henry Masondo. And I'll give you just a very quick taste of what you can expect from those 3 speakers. Abdul is originally from Nigeria, though he practices in the same set of chambers I do in London, Keating Chambers, where we specialize entirely in construction and engineering. And he practices throughout Africa and indeed the rest of the world as well, but specifically in Africa and particularly in Southern Africa, where he's often to be found in South Africa and regional areas, and of course, West and East Africa as well. So Abdul will be in the first panel along with Melissa Peter, who comes from HKA, one of the world's top bodies for expertise in many of the biggest and most important disputes throughout the world, and certainly in Africa. HKA will be providing expert witness services, and Melissa is very up to speed on project stumbling blocks from that angle, and you're going to find what she says of real interest. And then there's Henry Masondo from Zambia, who is an absolutely top civil engineer. He's the president of the Zambian Engineering Institution. He's chairman of the Association of Consulting Engineers in Zambia. So he is the top man, and he'll be able to tell you about Zambia and all the surrounding areas as well, from an arbitration and adjudication and dispute point of view. Then we move to adjudication, where there's a panel that has 3 absolutely top speakers. It has Jacko Della Rey, also from HKA, based in South Africa. It has Diana Nalawusha from Musa Dudla, and she hails from Zambia and will be able to give us the Central African perspective on adjudication, which, as you know, is the flavor of the month for dealing with disputes, so that you can avoid going on to arbitration and get a quick and relatively inexpensive tribunal decision. And then there's Ian Hendrick, who from the Murray and Roberts, who are one of the major contractors, not only in South Africa, but in the Middle East as well. And he's coming at it from a business point of view. He's the chap who decides whether there's going to be an arbitration, whether his company wants to invest in having a dispute, because they can be expensive. He comes at it with an MBA as an absolutely senior executive in one of the world's major construction companies. So we'll be getting a fascinating perspective there from him. And then we move to our third and final panel, which is on arbitration. And Abdul Janadu will speak again on an overview of arbitration in the African context, specifically Southern Africa. Then we have Virginie Collieratu from LMS Legal. She's based in London. She lectures on the King's College Masters in Construction Law. She has a doctorate from Paris and has a wonderful combination of civil law and common law expertise. So very helpful, and her presentation will be very exciting. Then we have Dan Tivador, who is not only an English barrister based in Three Hague Court. He comes with a law degree from Cambridge University, a BCL from Oxford University, but he currently practices partly not only in London, but partly in Harare, and of course does work as counsel and as an arbitrator throughout the region. And then we have Tim Harwin, who is from HKA. He'll be giving us the expertise he has not only in South Africa, but also internationally, looking at it from the point of view of providing expertise, experts' reports, expert evidence in cases, and so on. So we've got a real treat in front of us, and we go now to the first grouping, that's the project stumbling blocks, and over to Abdul Janadu.
Thank you, Robert. I hope you can all hear me. Thank you very much for attending today. I have 8 minutes to deal at a very high level with an overview of delay on projects in the continent. And what I intend to do is to deal with in a series of bite sizes. I'll begin with the overview of delay on projects. I'll then deal with delay related issues. I'll give an overview of the contractual methods which are provided to deal with delay. I will then turn to look at what I call the two prime drivers of delay, both the contractual and the extra contractual drivers of delay. And then I want to finish, if I may, with just essentially a worked example on the continent of a continent mega project that has been affected by delay. So having said that, I want to begin now with just by looking at, just give a very brief overview of delay. And it's always useful to start by defining terms. Delay, as I'm sure many of you here will know, is any prolongation or extension to the date of completion of the work or sections of the work. Now, delay is a prime driver of cost increases and cost overruns in construction projects globally, and in particular on the continent. And delay-related issues, in my experience, both as arbitrator and as counsel in arbitrations, delay issues are the prime cause of disputes, and they tend to lead to the most difficult and thorny issues in arbitration. A subset of delay overall are disruption issues, and disruption can be described as the effect or any cause that has the effect of disrupting the contractor's planned sequence, a method of work, such that either the progress is slowed, and or he's forced to increase resources, and or his resources are less productive than planned. So when we talk about delay, we also should bear in mind the subset of disruption issues. Moving on then to the consideration of how contracts address issues of delay. Again, forgive me, but this is all at a very high level because I don't have much time to deal with this. But in virtually all, well, in all the standard forms of contracts that are generally in use on the continent and globally, there are specific contractual provisions which address delay. And in virtually all of them, they adopt pretty much the same scheme for dealing with delay. You'll generally have a clause that identifies what the contractor's obligation is in terms of time. So complete by X date, complete sections, or the following sections by Y date, milestones, completions, etc., etc. So there'll be a clause that sets out and encapsulates the contractor's obligations in terms of time. There will then be generally a clause which provides for penalties in the event that the contractor does not complete by the time stipulated in the contract. And then in between, you'll find provisions that allow the grant of extensions of time and or money for delay. And these, again, tend to be broken down into clauses which set out what are widely described as relevant matters. So these are the matters which, if they arise, entitle the contractor to delay. And then there will be a clause which grants usually the project manager, the contract administrator, the engineer, whatever you call him, the power to award extension of time and or money. What these clauses essentially are risk allocation clauses. So the parties are agreeing in the contract how they divvy up the risk between themselves of certain things happening. So you'll have, for instance, clauses that make it clear that in the event of inclement weather, the contractor is entitled to delay, or on the giving of instructions, or the dreaded force majeure, you'll have that they will entitle the contractor to apply for an extension of time and or money. It should be borne in mind that time does not always equal money. It depends on the terms of the contract. Some relevant event in contracts will entitle you to additional time, but not additional money. So one has to be careful to make sure that you know what you're talking about when you're looking at the specific events. And then, so that's sort of that's the basic contractual framework that one works under. Now, bring it down to the continent and my experience of delay issues on the continent. I break these down really into two different buckets. There are those things that I term very loosely contractual prime drivers of delay, and there are those things which I call non-contractual prime drivers of delay. Now, what do I mean by that? When I'm talking about contractual prime drivers of delay, I'm talking about issues arising within the scope of the contract which give rise to delay. The biggest one of these, usually, in my experience in Africa, is payment, particularly when you're dealing with a government entity. Very often, money starts to run out in the contract and the contractor is not being paid pursuant to the terms of the contract. That will then usually trigger from the contractor a suspension of the works. That will then cause delay to completion. And an argument will arise as to, well, aside from the entitlement to payment, who bears the risk, who takes responsibility for the delay arising from the contractor's suspension? So payment is a big driver of delay, a big contractor driver of delay. Another prime contractual driver of delay in my experience are failures in contract administration. This is particularly true when you have forms of contracts such as the NEC, and increasingly the new FIDIC forms, which require active project and contractual management. With some of the older forms of contract, you know, the party would sign the contract and put it in a drawer, and nobody would look at it again until a dispute arises. But with the more modern forms like the NEC and the new FIDIC, there is now more of an emphasis on active contractual management and active project management. And failures to conform with the provisions of those contracts in that respect gives rise to delay. An example of this is if there is a delay in issuing or responding to requests for information from the contractor, or results or failures in ensuring that designs are crystallized and frozen by a particular point in time. So you have a continuing design process where the contractor is saying, well, I've done as much as I can with the design I have. I'm waiting on Mr. Engineer, Mr. Consultant to give me additional design through to progress the works, and failing that, there's delay. Those are the classic, what I call contractual drivers of delay. On the continent, we also have non-contractual drivers of delay. And these are issues which arise outside the scope of the contract, as it were. So what am I talking about here? The prime examples of these are, for instance, delay caused by changing governments and political uncertainty. Very often with large projects on the continent, if there's a change of government policy, what had been, you know, the blue ribboned, shining example of infrastructure, which government A had been pouring money into to get it completed, there's a change of government, that blue ribboned, shining example of infrastructure suddenly becomes the white elephant. And the contractor is there now faced with a less than permissive environment contractually, and having to deal with a more hostile employer who's not willing to progress the work. Another prime non-contractual driver of delay is insecurity and instability. And unfortunately, we've had a very recent example of that with the pulling out of Total from the gas fields in northern Mozambique. If for whatever reason you are contracted to build a dam or whatever, and you suddenly find that you're in the middle of hostilities, that's going to cause to suspend work, and that will be a prime driver of delay. Another one, currency fluctuations. If the currency in which the work is being, if the government finds that there's been a huge devaluation in the local currency, even though the contract is demarcated in dollars or euros, whatever, the government finds it more difficult to pay because there's been a huge devaluation, and that may slow down the works. That would also have an impact on the contractor if, to any extent, he's sourcing any of his materials locally. If there's a difficulty in getting hold of local currency, that will cause delay. Changes in legislation is another example of a non-contractual driver of delay. We have an example now with COVID, which has had an impact on construction projects, be it the inability to bring in labor because of new restrictions on movements across borders, just the general disruption caused by limitations on the ability of people to work on site because of COVID restrictions. All of that will have an impact on the progress of the works. And then a huge issue which is directly relevant to the work example I'm coming on to is our logistical issues. So if there are problems with clearing goods through ports, etc., that will cause the contractor delay and can give rise to claims. So coming on to my worked example, I picked the Dangote oil refinery, which is being built in Lagos, Nigeria. I know it's not Southern Africa, but it's one of the largest infrastructure projects on the continent, and I think, in my view, perfectly illustrates some of what what I've been talking about here in terms of delay issues arising. Now, the plan was announced in 2013. When it was announced in 2013, the planned production date was 2016. That slipped and slipped and slipped. They didn't actually break ground until that 2016. The plan was to build a 650,000 barrel per day oil refinery with an associated fertilizer plant and petrochemical plant. This project is a huge project. I mean, it's about $15 billion total. Once it's completed, it will account for about 150% of Nigeria's total needs for gasoline, kerosene, and diesel. So this one plant will supply the entire country with gasoline, diesel, and kerosene. And it was, as I said, it was intended to start production in 2016. There were delays related due to financing and design, meant they didn't actually break ground until 2017. With 2016, with major construction starting in 2017. Now, we're sitting here in 2021 and it's still not completed. Why is that? Well, a number of reasons. There were major logistical issues that Dangote experienced in constructing the refinery. The primary one being that there was such port congestion at the major ports in Lagos that he simply couldn't get his all the plant and equipment he required imported. And almost everything on this project is being imported. So when the port is up, that on the works, things got so bad that they ended up actually having to build their own wharf adjacent to the works so that they could actually bring vessels in off the high seas directly to their own wharf and unload at their wharf, trying to ameliorate the problems. In addition, they were employing somewhere between 15 and 20,000, mainly Indian and Chinese workers on the site. Now, COVID hits, and the government understandably imposes restrictions on movement. That had a major impact on the workforce. So the long and short of it is that we're here in 2021, still not a barrel of gasoline produced. The latest estimate for production is that we'll have some form of mechanical commissioning by the end of this year, with production starting in 2022. So that illustrates, very briefly, some of the issues that you'll find when you're dealing with large projects on the continent and the sorts of delay issues that can arise. I hope I have stuck to the time that Robert's given me. I'm sure if I hadn't, he would tell me. And I'll be happy to take any questions at the end. Thank you.
Thank you very much, Abdul. And now we move to Melissa Peter, who's going to be telling us how things look from the HKA perspective on project stumbling blocks. Over to you, Melissa.
Thank you, Robert. I will be speaking to the core drivers of delay and cost overruns on projects in the South African space. I do note that whilst there are several factors that cause delay and cost overruns on projects, I've listed them in a number of categories. In no particular order, I'll be speaking to design-related factors, contract-related factors, labor-related factors, project-related factors, external-related factors, owner and contractor-related factors a little bit later on. Just to give an example of design-related factors, very similar to what Ahmed's already confirmed, when we talk in design-related factors, we find that design quality is very poor. We have inadequate and incomplete specifications at time of tender. Contract-related factors, an example of that may be ambiguities in the contract documents, as well as instances whereby the parties have different interpretations of the contractual or the contract provisions. Labor-related factors would include things like high absenteeism, low productivity, morale of labor on site is low. Some external factors would be weather conditions, legal and other economic factors. And then I will be speaking a little bit more in detail to owner or client-related factors, as well as contractor-related factors. So whilst there are several factors that cause delay and cost overruns on capital and infrastructure projects, based on my experience in the construction industry over the last 18 years, as well as studies that have been conducted in South Africa over the years, I found that there are higher incidences of delay and cost overruns that are caused by either the contractor and or the client. I'd like to dive into one of the factors, one of the client-related factors in a little bit more detail, and that is the incomplete or rushed feasibility studies. So I'm just zooming into the pre-construction phase of projects at the moment. So speaking to incomplete and rushed feasibility studies, I have been fortunate to have taken part in a number of project scrubbing and lessons learned exercises on some prestigious construction projects in South Africa. And we've often found that project stakeholders are very eager to get their projects up and running as soon as the business case and the budgets have been approved. As a result, the consultants or the teams tasked with conducting those studies are given a very limited duration in which they are to complete the studies. So pre-feasibility and feasibility studies. The rushed and incomplete feasibility studies often lead to a number of impacts or effects on the projects. One of those are, again, we have incomplete designs issued at the time of tender, and later on the same issued to the successful bidder for construction. We also have, in those, as a result of those feasibility or rush feasibility studies, we have high-level programs or program summaries and project durations that are included in these tender documents, which are unrealistic and unattainable from the onset. Another one that we would have is inaccurate cost estimates for the project from the same rushed feasibility studies. Risk assessments and risk profiling is also inadequate. A realist view is that every project carries inherent risk. Therefore, prudent course is to anticipate, recognize, quantify, and make provision for those risks in both the cost and schedule estimates. Therefore, due diligence, in my opinion, is during the pre-construction phase is vital for project success as well. I'd also like to add that the experienced contractors identify those client risks, which are opportunities for them at the time of tender. So contractors during the tendering phase, when they are planning, budgeting, putting execution plans together, they identify these opportunities, which are the client's risks. Whilst they are developing their programs for submission with their tender documents, they make provision for these opportunities in their programs very early, at the very early stage of the tendering process. And they make sure to include these opportunities in their programs, and to make sure that those events, future events, are included on the longest or critical parts of their programs. and almost immediately those give rise to an extension of time entitlement to the successful contractor. Also, I believe that due to the competitive nature of the bidding process, the contractor is almost forced to develop schedules to fit within those unrealistic and very tight schedules, because the project start and end dates are provided to them in the project or the tendering documents. Another event that is common in our space is that of client access delays. So the client provides access to the contractor late, or he provides access to the contractor which is fragmented or partial access. These events lead to a number of delayed access claims and or disruption claims. Other client-related factors that I won't go into too much detail is changes to the scope of work. This is one of the top causes of claims and disputes in the South African space. We have a lot of slow decision-making by the client and inadequate responses to information requests from contractors. We also have inadequate contract management on site, engineering and other approval delays that occur very frequently on site as well. We have a lack of communication and coordination between parties on the projects. Another key one for me is poor interface management. So you have these very big programs on the go in South Africa. You have multiple contractors on site, but we have a lack of a master program, or the master program is deficient. And you also have very poor interface management by the client with all its contractors. So information coming into the master program is inaccurate, and then you're using that information as an output to other contractors. So it's a knock-on effect from one contractor with unrealistic forecasts to the next contractor down the line. I've just summarized a few contractor-related factors. One of those is, I think, a knock-on almost from the client's inefficiencies, is ineffective planning and scheduling. So in the South African space, we have a lot of people, or a lot of schedulers in the South African space, but very few planners. So we don't have enough planners or with the sufficient skills in the South African space. We find a lot of delays in the progress of the works with prolonged activity durations. So on the onset, the contractor estimates unrealistic activity durations for particular tasks. And we find in most instances, those activity durations are unrealistic. And you find that those activities are prolonged over time. We also find that there's poor monitoring and controlling on site by the contractor. And I do believe that thorough and accurate reporting is necessary in order to eliminate any uncertainty on the project. We find a lot of deficiencies in workmanship. So you have a lot of reworks on site, which again takes up a lot of time and a lot of effort by the workforce. Low productivity is another contractor-related issue, and again, poor quality workmanship. We find that poor and less experienced contractors, even with the most impeccable designs, cause some very costly mistakes, which again further delays the projects. And I think that's all from me, Robert.
Well, thank you very much, Melissa, for a very interesting presentation. And that takes us across to Henry Masonda, who's going to be looking at things from a Zambian and international perspective as a top civil engineer. Over to you, Henry.
Robert, thanks, and good afternoon to everyone, wherever you are. Abdu, Melissa, and the previous speakers have preempted a lot of my comments I'm supposed to make, but I'll try and meander through what they've covered already. I think what is clear from the presentations so far is that when look at the delays and cost overruns, the biggest issue is risks, which has been well articulated by the previous speakers in panel 1 and the 2 in my panel, and that risk costs and time overruns. And in fact, you can link the delays and cost overruns to causes of disputes. I am fortunate to practice in a lot of African countries, and you can see these problems popping up on the various projects. I think Melissa also made a point that the risks are inherent in any contract, and that is true. But to try and keep within the time, and I just want to add 1 or 2 points on the contractor-driven delays, which has not been covered by the previous presenters. And this is from the personal experience from Ethiopia, Uganda, Malawi, and coming down all the countries, that you can see a trend, especially with the Chinese contractors, which was a major discussion in panel 1. The use of agents in pricing projects is a growing trend, and these do not take into account a lot of risks on the project, and they tend to price it from the previous pricing in other countries, and they keep on pricing them in whichever country they go. And their interest is to participate and take a share of the market, and they are willing to underprice to simply get a project. And this causes delays and eventually disputes. Another problem is there's a trend, like in at the beginning of the century, the last century, the movement of contractors and breaking up in smaller groups from China means that it's the same people you are dealing with. You go to Ethiopia, you find the same ones. The one who was a clerk on one project becomes a project manager in another country. So you have these people who are inadequately experienced, very young people, reforming groups in different countries and forming up new construction companies under almost similar names, group 3, group what, group this. And that also causes problems, that they are involved in very big projects, but with inadequate skills of planning and risk assessment and in their pricing as well. Another problem related to the problems of the movements of contractors from one country to the other is the delays in mobilization on projects, because they have to rely on equipment from another country. You can imagine the amount of plant and equipment that has been brought into Africa by a lot of Chinese companies. Those equipments cannot be thrown away after one project. They have to move from one project to another. And if they can't get a project in one country, they will move the equipment to another country. And sometimes you find on one project, there's 72, 70, 100 trucks, which are just parked, most of them obsolete. And that is causing delays because of poor equipment and poor planning. And I think so you find that because of the failure to get competent personnel at the beginning of the project, you have missed opportunities in them evaluating and notifying risks relating to geological sites, data issues, unforeseen physical conditions on sites. And this has then causes delays, and then you run into time overruns and disputes on projects. So I think I'd like to end here in trying to keep within the time for the team. And since they've already profiled the issues.
Thank you very much. Thank you very much, Henry.
Thank you.
Right. Thank you very much for that very interesting presentation. Now that brings us to group, which is going to deal with adjudication. And we're going to start with Ian Henstock from Murray & Roberts. And as I've mentioned, this is an executive of an international company practicing throughout Africa and the Middle East, and he'll tell us his take on when to trigger a dispute. So over to Ian. Ian, you're muted. Ian, you need to unmute yourself.
Can you hear me? Can you hear me?
Yes, we can.
Yes, now you're unmuted. Good.
Okay. I seem to have a bit of arm wrestling with the administrator there on unmuting. Robert, I just want to add that we have significant operations in Australasia and the Americas as well. So I'll draw on that experience as well. I'd like to kick off by saying practically why we like adjudications. And that is simply because it gives you quick... can you hear me? Robert, can you hear me?
We can hear you, Ian.
Okay.
Yes, absolutely.
Okay, thank you.
Yes, I can certainly.
The reason why we like to adjudicate as a step before arbitration is that it gives you quick access to cash. In fact, it's so important to access cash in a dispute environment that in Australia, it is a subject of their statute that contractors can adjudicate whether or not it's written in their contracts. And that's to make sure that contractors have access to cash quickly where they are in dispute. We also like adjudications because they're procedurally less complicated and more importantly, often because their outcomes are accepted. We were involved in a 4-year project where there were in excess of 150 adjudications and only a handful of them went to arbitration. So you can see we were in dispute on a number of issues, but not sufficiently in disputes such that they went through to arbitration. And in many cases, they were small and they were dealt with as cluster disputes as well. One has to ask the question, if you know a dispute is going to be settled in arbitration, why would you take it to adjudication? We've done this in one particular case where we had a very complex and unusual dispute. And we wanted to test, not in a binding forum, but in a forum that was appealable. We wanted to test the approach that we were going to adopt. We also wanted to see how the client would respond in those circumstances. And so in preparation for arbitration, knowing we would go to arbitration, we still took it to adjudication and incurred that cost for the sole reason of testing our case in adjudication, which, as you know, is appealable. When it comes to members of the DAB, we always insist that they be lawyers. We never accept a subject matter expert as a DAB member for the simple reason that a DAB is a judicial process. And if there is a specialist matter or a subject matter that has to be decided, you get specialists to act as expert witnesses to assist the panel in coming to the appropriate conclusion. I'd like to give an example of where this worked out well for us. In the Middle East, which, as you know, is a jurisdiction governed by civil law as opposed to common law. So one of the sections of our agreement was covered by the codes or regulated by the codes. And so we had to have the code interpreted and then understood what it meant. So we got a professor who was a professor in Arabic, the language. We asked him to translate the section and then interpret what it meant to us and how it affected us. We then took that to the case, and the opposing party did the same thing. And the two subject matter experts gave different views of what an Arabic term in the codes meant, or how it was to be translated and how it was to be interpreted. So imagine if one of those members, who is a subject matter expert, was sitting on the panel and influenced the panel with his or her opinion, it would have been to the prejudice of one of those parties. So we always choose lawyers, legally trained people to sit on our adjudications and our arbitrations for that matter. And we leave subject matters to expert witnesses. And then just lastly, in the interest of time, and I know that Jaco is going to cover a number of of related subjects, I want to turn to the standing DAB. Now, we like standing DABs. It works well, especially where we have long-dated contracts, and we have many of those globally. But you must keep in mind that in a long-dated contract, your standing DAB is going to change due to sickness and death. In 2 occasions, we've had 2 adjudicators called to the bench and become judges. And also, we must take into consideration familiarity with the case, where people become over-familiar. So where you have a standing DAB, you know in a long-dated contract, you are going to have to replace members with different people. So cater for that in the beginning as well. It's going to happen. But more importantly, the question of familiarity. We found in a 12-year contract that the standing DAB became what we thought was over-familiar with the terms of the agreement. And by mutual agreement with the client, through that entire process, we nominated probably about 5 ad hoc DABs, notwithstanding that we had a standing DAB. So there's no such thing as an ad hoc DAB that stands on its own, or a standing DAB that operates through the duration of the contract. We've had a combination of both. So those are just some of the thoughts that or some of the issues that I thought I'd share with you for the sake of interest. But happy to answer any questions after the panel session. Thank you.
Thank you very much, Ian, for that. And now we go to Yakadela Ray from HKA, and he'll be giving us his perspective from both the South African and regional point of view.
Well, thank you very much, Robert. And I think Ian has touched on some interesting and pertinent points. I'm going to try and run through a couple of questions that was posed by yourself and hopefully address a few views for you. To start off with a brief overview of the case for and legal basis of adjudication in South Africa. We're no different from the rest of the world when it comes to adjudication matters. In order to survive an ever-increasing and competitive environment, the old saying, cash is king, is probably more relevant and important in developing countries. With an industry plagued by an unfortunate culture of late payment, contractors need a mechanism which resolves payment disputes in a rapid, inexpensive, and contemporaneous manner. And I think Ian quite poignantly touched on that. So since the early 2000s, contractual adjudication has gained traction and remains the preferred ADR method in construction disputes in South Africa specifically. The drawback is that there is currently no statutory adjudication framework in South Africa. So the status quo is that locally, by way of the four primary standard forms used, JBCC for building, GCC for civils, and NEC and FIDIC in the engineering construction sectors, contractual adjudication is used as a compulsory first ADR method prior to proceeding to arbitration or litigation. Secondly, how popular or successful is adjudication as a means of resolving disputes and why? Well, I would say popular or successful in terms of being utilized, yes, because it's incorporated in those contracts. Successful as in effective, I guess the answer lies in the eye of the beholder. Is it cost effective? It really depends on the size and complexity of the dispute. When it's just about interim cash flow or resolving contemporaneous issues during the project, it's more likely that it can be cost effective, yes. But it's when the dispute process is delayed to the 11th hour of the project that the complexity of the disputes tend to become compounded by layers of discord and involve multiple issues relating to the contract, notice provisions, ad hoc claims, and dispute moratoriums are quite common. Scope interpretations and progress delays and cash flow. So too often these challenges result in an amalgamation, if I can call it, of both ineffective procurement and contract management. this includes matters such as procurement and contract strategy, integration and timing of design and construction, contemporaneous records, lack of formal communications, ineffective reconciliation of progress payments, inaccurate project scheduling and notices and responses, etc. So disputes referred to adjudication on these propositions often suffer at the expense of cost and time. And although adjudication is fondly referred to as rough and ready justice, the emphasis must remain on justice. And on complex disputes, we unfortunately find that awards sometimes lack coherent reasoning. Looking at what sorts of disputes are being adjudicated, one could say that it ranges from most trivial and often unnecessary to highly complex matters, both contractual and technical. It's likely that the theorists would agree that the disputes most suited for the fast-paced world of contractual adjudication lie somewhere in the middle. HKA conducts ongoing research into the causes of claims and disputes and publishes its findings annually by way of the HKA Crux report. The 2020 Crux report looks at over 11,000 projects across 88 countries. And the objective of the research is really to assist stakeholders to make better choices and decisions that could prevent or reduce possible claims and disputes. This data can be filtered by way of multiple factors such as regional and countries, sectors and subsectors, contract types, procurement routes even. And from the latest data, we've found the top 5 root causes across all regions as change in scope, incomplete designs, poor management of third parties, inadequate contract management, and deficiencies in workmanship. Now, whereas if we compare that to the Southern African regional analysis of causation, we find quite a different hierarchy. They are restricted site access, change in scope again, contract interpretation, again incomplete design, and then cash flow and payment, which don't appear on the top 5 of global stats. I think Melissa has very eloquently highlighted the issues that often develops into disputes. And so it's clear that different regions, countries, and even sectors may promote alternative focus areas to avoid or reduce disputes. In terms of the procedures typically adopted in adjudication, this is an interesting point. The first observation is that disputes are not being referred contemporaneously. Typically, the parties prefer to attempt a negotiated settlement of sorts. And years later, the dispute that finally gets referred to adjudication is often not suitable or capable of being determined within the contract timelines, and inevitably a more complex and lengthy process is necessary. Insofar larger and more complex disputes are concerned, the procedures are largely influenced by the size, capacity, and project knowledge of the tribunal. So yes, standing DABs tend to function more efficiently in this space. But in ad hoc adjudications, we see challenges. Standard procedural timelines are readily amended. Multiple submissions are not uncommon, and formal or informal hearings are introduced. So it's of most concern is that it's not uncommon for parties to divert from that agreed process by introducing new arguments and evidence at the last moment, literally often at the last day of the hearing. So our general impression is that many adjudicators don't afford enough weight to the agreed procedures, allowing the parties to overstep the agreed boundaries. Essentially, larger disputes are often conducted in a quasi-arbitration fashion, without all the structures that accompany formal arbitration. Obviously, the two elephants in the room, would be the absence of discovery and cross-examination, which clearly don't assist the tribunal much. Who sits as adjudicators? Since adjudication in South Africa is a creature of contract, there's very little guidance or formal standards to qualify as an adjudicator. That said, a number of quality courses are available in South Africa, and various industry bodies have created adjudicated panels. To register as an approved panelist, candidates need to satisfy certain predetermined criteria of practical experience, legal and technical qualifications, and go through a peer interview process. Notwithstanding, we find it's predominantly represented by the legal profession. Retired judges and advocates are popular. More technically qualified adjudicators include QSs, engineers, architects, and project managers, etc. The concern's not so much who sits as adjudicators. It's really about whether they are suitably equipped to deal with the specific dispute that lands before them. And so the solution's obviously not simple, but there's a case to be made that a multidisciplined breed of adjudicator would be ideal for more complex types of disputes. And depending on the nature, size, and timing of the dispute, arbitration may be better suited from the outset. In looking at enforceability of adjudicators' decisions and how supportive our courts are, without question, over the years, the courts have shown a healthy appetite for supporting and enforcing adjudicators' decisions. Apart from serious procedural irregularities, the prospect of resisting enforcement of an adjudicator's decision has proven unlikely. Having looked at the cases to date, I would say that the courts recognize the value of adjudication as an effective mechanism to not only relieve the burden on the courts generally, but to ensure contemporaneous payment of works properly executed, and to deal with matters more suited for technical experts, and resolve parties' grievances more cost effectively. Ultimately, recognizing that the purpose of adjudication, as Ian rightfully mentioned, is to obtain an independent and objective decision on an interim basis, which, although immediately binding on the parties, is not final and subject to procedural compliance. It remains open to review in a more formal environment such as arbitration or litigation. Finally, in terms of the status of legislative reform and intervention in South Africa, the Construction Industry Development Board published the proposed prompt payment regulations and adjudication standard back in May of 2015. The primary objective of the proposed regulations is to address the chronic payments default in the construction sector. It is to ensure effective cash flow for works properly executed by way of prohibition of pay when paid clauses, to regulate progress payments within statutory timeframes, allow for suspension of performance due to non-payment, and to prohibit withholding of payment, and provide for punitive interest to be charged on late payments. Closely linked to this is to widen accessibility to a rapid, inexpensive, and contemporaneous dispute resolution mechanism by way of effective statutory adjudication. Now, this was released for industry and public comment and recommendations, and notably the proposed regulations were met by significant pushback from the public sector and the state-owned enterprises. And in conclusion, unfortunately, although the industry generally recognizes and welcomes the value of statutory adjudication, no real progress has been evident in this space. Thank you. Back to you, Robert.
Thank you, Jaco. And now we move to Diana, who will be giving us a perspective from Zambia, but also throughout the region. Over to you, Diana.
Thank you so much, Robert. Thank you, Jaco, for that presentation. My presentation will take a similar format to that of Jaco's. I will speak to several points that he touched on. To start with, looking at the legal basis for adjudication, in Zambia, we don't have a legislative reform that has yet codified adjudication. It's basically, adjudication is contractually driven, and parties to construction contracts agree certain disputes that would be determined by adjudication. how popular or successful is adjudication as a means of resolving disputes? Like many modes of alternative dispute resolution, adjudication is usually preferred because it's considered cheaper and quicker. Also, the fact that it's confidential makes it more attractive to parties. But however, also on the other side of the coin, because it's confidential, it's hard to tell how successful it is. There is no place that keeps a record of how many disputes have been adjudicated and how many were finally resolved or determined through adjudication without the need to proceed to arbitration or litigation. When it comes to what sorts of disputes are adjudicated, from my experience in the Zambian market, what I've come to know is that parties prefer to adjudicate claims relating to interim payments, delay and disruption of the works, extension of the completion of works, or defects in the works, and final accounts. Adjudication will not usually be used for parties seeking creative remedies or overly complex technical or factual disputes. For instance, I have been involved in a dispute where the dispute largely related to remedial, attending to remedial works for defective works. The contractor was adamant that it would not attend to remedial works until it received payment from the employer. And the employer was also adamant that it couldn't make any payment until the defective works were remedied. It got to a point where the employer, wanted to get rid of the contractor and employ another contractor to complete the work. And the contractor, on the other hand, did not want to leave the site. So the employer wanted to get some sort of injunctive relief to remove the contractor from site. But because the contract was expressed that any dispute between the parties would only first be resolved through adjudication. If that failed, then arbitration. The immediate relief sought by the employer was not possible because adjudication, a party cannot obtain interim injunctive relief through adjudication. You would have to go to court or to arbitration. But because of that hurdle in the contract, the employer could not move the contractor from site. So it's almost important these days to stipulate what disputes should be adjudicated to leave room for such events. If the contract was clear that in an event that one of the parties sought injunctive relief, for instance, that dispute would go straight to arbitration or straight to court without first jumping to adjudication, the relief sought by the employer in that case would have been obtained. We move on to the procedures that are typically adopted in adjudication. Because adjudication is contractually driven, parties will beforehand agree what procedures will guide adjudication should a dispute arise. Like Hiako said, adjudicators normally have discretion to decide how adjudication will be conducted. They would agree with the parties whether a hearing will be necessary, whether written submissions will be required from either parties. And I've worked on instances where an adjudicator has also requested to have a site visit to determine the dispute before him. And when it comes to selection of adjudicators, there is no general guideline that sets out the qualifications that one has to hold in order to sit as an adjudicator. The contract primarily will will guide what the parties should take into consideration in choosing an adjudicator. But generally, some of the factors that are considered include the nature of the dispute, potential conflicts of interest between the possible adjudicator and either of the parties, whether the particular dispute is one of several adjudications on the same contract. If it is, it's usual to nominate the same adjudicator because of the potential savings in costs and time. The language that is required to resolve the dispute is also one factor that will be taken into account. In terms of enforceability of adjudicators' decisions, because adjudication in the construction industry in Zambia is not as yet recognized by statute, enforcement would have to go through arbitration or litigation. A party seeking to enforce an adjudicator's decision would necessarily have to depend on court or arbitration. However, if that route was taken and arbitration was sought, an arbitrator is not prohibited from determining the rights and obligations of each party as though the adjudication never took place. So the courts or the arbitrator will not be bound by the adjudicator's decision, and they can treat it as evidence in most cases. The decision will be part of the evidence that the parties would rely on, but it would not necessarily mean the successful party at adjudication would have a clear-cut enforcement procedure. This is unlike places like the UK that have mechanisms, put in place mechanisms such as enforcement through summary procedures before the Technology and Construction Court. Because of the growing industry, the growth in the construction industry in developing countries like Zambia, it is pertinent that we as advocates push to recognize adjudication under statute.
Right. Well, thank you very much, Diana.
Thank you, Robert. That's all from me.
Thank you very much. And now we move to our final grouping, which is on arbitration. And we start with Abdul Junadu, who will be giving us an overview. So over to you, Daniel. Over to you, Abdul.
Thank you, Robert. Apologies. I start with an apology to anybody who, any lawyers that are here, or anybody who has, who deals regularly with dispute resolution. This is a very, very high level run through in 8 minutes or less of dispute resolution clauses and contracts. So please forgive me if what I'm saying is, to many of you, blindingly obvious. But hopefully it'll be of some use to some people who are on this in this conference. So contracts, as I said in my earlier talk, will provide for dealing with generally extensions of time, allocating, awarding extension of time or loss and expense. Most standard contracts also deal, or will invariably have dispute resolution clauses that tell the parties how they are to resolve their disputes. In major construction and engineering contracts in Africa, almost invariably, the ultimate tribunal for dealing with any disputes will be arbitration. arbitration is preferred certainly over litigation in local courts for a number of reasons. One, there is a general lack of confidence in the independence in some jurisdictions of courts, but even in jurisdictions where those issues don't arise, you very often have concerns about home court advantage. Contractors, particularly foreign contractors, will be reluctant to submit their disputes to local courts because they're not familiar with the courts, they're not familiar with the procedure, and they'll feel that they'll be more comfortable dealing with their disputes in arbitration, which, if they're experienced international contractors, is a form that they're more familiar with, which is a huge incentive to provide for arbitration. There's also a concern about a lack of expertise in local courts. In the UK, we are very fortunate that we have a specialist construction court that deals with construction and engineering matters on a daily basis. That's not the case in most of the world. And this is not just limited to Africa, this is globally. There are very few jurisdictions that have that luxury of having a specialist court where the judges deal with construction engineering disputes day in, day out, and very familiar with all the relevant concepts. And the one huge advantage of arbitrating is that you can pick your tribunal. I think Ian also mentioned with adjudication. Because it's a privatized means of dispute resolution, the parties have the flexibility to pick who they want to act as their tribunal. So they can have purely technical people on tribunal, have purely lawyers, or have a mixture of both. And they can pick people with the relevant experience, the point to granular level where you may want somebody who has had experience of dealing with railroad disputes in Zambia in the last 5 years. If that's how detailed you want to make it, then you can choose to do so. And then finally, and this is something that I know from experience of my home jurisdiction, Nigeria, the enormous delay you sometimes find in local courts. It is not unheard of for disputes in some jurisdictions of the continent to last anywhere from 10 to 15 to 20 years on a simple contract dispute. So for all of those reasons, parties will tend to look to have private methods of dispute resolution provided for in their contract. But I should make clear from the outset, I'm talking, my talk is generally about commercial arbitration and commercial dispute resolution. Virginia will talk to us about bilateral investment treaty disputes, which is a entirely separate body of learning, which she will deal with. So that explains why parties, I've sort of explained why parties will go to dispute resolution, have their own private dispute resolution procedures in contracts. One increasingly common feature in construction contracts are what are called tiered dispute resolution clauses. What we mean by tiered dispute resolution clauses is that rather than having one method of dispute resolution, the contract will provide for a series of steps, a series of tiers that essentially are escalating towards a final dispute resolution procedure, which almost invariably is arbitration. Before you get to arbitration, you have to jump through certain hoops. And it all depends on the particular contract, but you may start off with a decision of the engineer on site, followed by mediation, followed by negotiation, followed by adjudication, and then arbitration. Some contracts make going through all of those hoops mandatory. So you can't go to one without having been to one before. So FIDIC, for instance. Other forms of contract allow you to skip certain routes. And if you decide that you don't want to bother with mediation or negotiation, then you go straight to adjudication or arbitration. That can happen as well. It all depends on the contract.
Right.
So dealing with the specific steps now. So negotiation essentially it is what it says. It's parties deciding to negotiate between themselves a resolution of the dispute. This can be formal or informal, structured or unstructured, and it's up to the parties to decide who takes part in the negotiations. Very often, it will be senior executives coming in to attempt to reach a commercial resolution to the dispute. The big advantage of negotiations that allows parties to take into consideration purely commercial issues, which wouldn't be the case when you're dealing with a more formal dispute resolution procedure. So things such as the desire to maintain a continuing commercial relationship factors into negotiations and the outcomes in negotiations. Engineer decisions. Engineers under forms such as FIDIC can provide, will be required to make the determinations if a contractor or the employer under the new FIDIC forms makes a claim to the employer, to the engineer will have to issue a decision which then issues to the parties, and that's temporarily binding. Another step similar to the engineer decision, but it is expert determination. Expert determination is a process where the parties agree to refer their disputes, usually technical disputes, to determination of an expert. And that expert will make a decision which is binding on the parties. We've heard about dispute boards already. The two types of dispute boards: dispute review boards and dispute adjudication boards. Dispute review boards make recommendations. Dispute adjudication boards make decisions that are binding, at least temporarily binding, until resolved by the parties in whatever the final form of dispute resolution is. And then coming on to the final form of dispute resolution, as I said, most commercial arbitration, so most commercial construction contracts, it will be arbitration. And the main differences are between ad hoc arbitrations and institutional arbitrations. Ad hoc arbitrations are arbitrations where the parties agree between themselves to run the arbitration. They decide to pick the arbitrator themselves, and there's no involvement of an institution. Institutional arbitrations, most popular on the continent, ICC, LCIA, GIFC, they administer arbitration to the parties, and they have procedural rules under which the arbitrations are run. A recent development on the continent is that there's been a mushrooming of arbitration centers and arbitration institutions in Africa. So you have the Kigali International Arbitration Center, the Lagos Chamber of Commerce International Arbitration Center, the arbitration centers in Nairobi, etc., all of the continent, all vying to get some of the arbitration work.
Abdul, I think you're winding up.
All right. Yes, I am, Robert. So I'll go very quick. Yeah. So, well, essentially that's it. I mean, that's a very quick run through arbitration, and hopefully, I've made some points that people may find interesting. Thank you.
Thank you very much. And now, for an overview of investment treaty arbitrations, we go to Virginie. Over to you.
Thank you, Robert. Abdul has described the methods to resolve construction disputes that typically derive from a construction contract agreed by companies or individuals or entities. I will address how some disputes may be resolved through arbitration or court proceedings on the basis of international treaties. In particular, treaties signed between sovereign states for the promotion of foreign investments. Many of these treaties exist between African states. They can be between two states or among various states. And for that reason, they are called bilateral investment treaties or multilateral investment treaties. And many of these treaties allow contractors to start arbitration or court proceedings directly against the state where their business activities are conducted. Also, an incorporated joint venture may have standing to start proceedings if the treaty provisions allow that. And very often we know that in construction contracts, contractors create an unincorporated joint venture, And when they have problems, that joint venture, if the treaty provides for it, can have a standing to start proceedings against the state. And in many cases, there is no need for a specific arbitration agreement or a specific contract with the state, because the right to start proceedings against the state directly derives from the provisions included in the treaty itself. And the choice between court or arbitration proceedings is also often up to the contractor, who must fall within the definition of a foreign investor. So ignoring the rights that may derive from international investment treaties may mean to miss the opportunity to solve difficult situations and difficult disputes. The only aspect is to ensure that a treaty exists and applies to your business, to your commercial activity. So let me give you two examples to explain how international treaties may be relevant for contractors. Let's suppose that we have an Italian contractor hired to complete a construction project in Qatar. I will not refer to any African state to avoid any problem. But you have to assume that these treaties and conditions exist also in relation to African states. So the Italian contractor concludes a main contract with the Qatari employer and a subcontract agreement with the Qatari subcontractor. The project starts and everything goes well until about 1 year afterwards, where a new law is enacted in Qatar, introducing a new fiscal regime, which includes the imposition of a tax to be applied back from the start of the project, that is retroactively. As a new tax represents a significant cost, disputes arise with the employer and the subcontractor about who should bear the cost for the new tax. And in such disputes, typically the companies will try to attempt to resolve the problem by focusing on their contracts, and would not consider that the new tax may represent a violation of an international treaty, and that would entitle the contractor to commence an arbitration procedure against the state of Qatar. So by ignoring the rights deriving from the Italy-Qatari treaty, the contractor would totally miss the opportunity to have its rights recognized and the tax to be deleted. In fact, there is a treaty between Italy and Qatar. In Article 2 of such a treaty, foreign investors, and the contractor may qualify as a foreign investor, must be accorded a fair and equitable treatment. And that fair and equitable treatment must be in compliance with principles of international law. So they are not judged, the situations which correspond to a violation of fair and equitable treatment according to the Qatari law, but they are assessed with reference to principles of international law. So the new law imposing a retroactive tax could be considered unfair with respect to the investor in light of the principles of international law, because it is retroactive. And indeed, the Article 2 of Italy-Qatari Treaty says so, because it indicates in its third paragraph of the same article that no changes in law may apply to the investor's investment retroactively. So if a state has violated its promises, the Italian contractor may, on the basis of the treaty, commence court or arbitration proceedings. And the rules that would apply to those proceedings would be found directly in the provisions of the treaty itself. And the right, in fact, in this particular case, for commencing arbitration proceedings is found in Article 10.3 of the Italy-Catay Treaty. Again, I'm referring to the Italy-Catay Treaty as an example, but many bilateral or multilateral investment treaty has a similar provisions and can, in fact, offer similar rights, and this is happening also in Africa and for many African states. So another relevant scenario which can give you also an idea of other unfair acts and measures that could lead to arbitration proceedings against a state is one referring, for example, to a Swiss company, a Swiss contractor, which has entered into a private-public partnership, for example, with a state entity in the Philippines. And the contract provides for the exclusive jurisdiction of the courts, the judicial courts of the Philippines. When a dispute arises, because, for instance, the state entity of the Philippines breaches its contract obligations, abusing its position as a state entity, the normal intuitive approach to solve the dispute would be for the contractor to look at what the dispute resolution clause in the private-public partnership provides. But in this particular case, because there would be a treaty between Switzerland and the Philippines, that treaty has also a specific provision that allows the Swiss contractor to start arbitration proceedings against the state because the contract breach perpetrated by the Philippines state entity, abusing its own position, powerful position, can amount to a treaty breach, so to a breach of the international treaty and the promises made therein by the state of, by the Philippines towards foreign investors, and in particular towards Swiss foreign investors. So in this way, there is the possibility for the Swiss contractor to avoid having its dispute against a a state entity of the Philippines before the local courts in the Philippines, in the event there is any concern about whether the local courts could render an impartial decision. So the terms of who commence arbitration or court proceedings, when those arbitrations can be commenced, and what violations can justify those proceedings are all explained and defined in, they are all defined in the provisions of the treaties themselves. So I hope that this has been useful for you to just have an idea of why you would need to get more knowledge about investment treaties.
Thank you very much, Virginie. And now we go to Daniel, who will be addressing us from a Harare perspective, coloured with a London angle. So over to Dan.
Great, thank you very much, Robert, and good afternoon, everyone. As has been previously stated, this is going to be a sort of a very quick tour de force in 8.5 minutes. But I would like to start with a couple of general overview points about construction arbitration in Zimbabwe, and then move on to a couple of local challenges and how to overcome them, how to manage them and avoid them. In terms of general overview, the good news is that there is a fair amount of construction dispute work in Zimbabwe. And for those of you who attended panel 1, it sounds like there's consensus that there's a fair amount of project work coming in the pipelines as well. The simple reason being that a lot of that construction work is needed in this region. Turning to arbitration in particular, I think the starting point there in relation to Zimbabwe is that arbitrations in this country take place in a very well-established statutory framework. And that is because 25 years ago, when the Arbitration Act was passed in 1996, it simply incorporated into domestic legislation the model law. And that applies now for domestic arbitrations as well as for international arbitrations. It also applies for the recognition of arbitral awards. And not only was the model law itself incorporated into domestic law, actually the Arbitration Act says that it's mandatory for local courts to have regard to the international jurisprudence that has been built up in 90 plus countries around the world. The reason why I start with that point is because if you happen to end up in arbitration as a representative or an expert in this country, I don't think you should be expecting any surprises. The law and the statutory framework is, as I say, one that is used all over the world. Now, I'm going to move on to a couple of challenges that may present themselves in Zimbabwean construction arbitration. And I call them challenges because I do believe that they can be managed, but I think it is useful to be aware of them. And in particular, I'm going to focus on three. I will start by examining the appointment, selection and appointment of arbitrators. Then I'm going to move on to the rules and procedures typically adopted in Zimbabwean arbitrations. And finally, I'm going to speak a little bit about expert witnesses in the arbitration context. So starting with the challenge of who to appoint, and Abdul has made some very interesting points about the quality of the judiciary in the region. Well, I should say that in Zimbabwe, I think the starting point that we all have to accept is that this is a much smaller and much less sophisticated and specialized jurisdiction than some other international as well as regional jurisdictions such as Johannesburg would be. That is not to say that there are not a number of very competent, hardworking and user-friendly arbitrators. But I can say that there's also a great number of arbitrators who one wouldn't really wish to have on an arbitration panel or sitting as a sole arbitrator in a tribunal. And the challenge is how to avoid that. And I would really emphasize that I think a lot of work needs to go into the selection process because the quality that one receives can be, there can be a great divergence in that. And so there's nothing wrong with interviewing arbitrators, obviously, bearing in mind that you must not conflict them out. And I would encourage everyone to contact local practitioners who have used those arbitrators as professionals or appeared in front of them and so on. What one should not do, in my view, is simply go to international directories and see who's tier one and just go for that person. If I may move on to rules and procedures in arbitrations in Zimbabwe, the first point to note, which is fairly surprising, is that rules are typically not adopted in Zimbabwean arbitrations. In fact, in my sort of 8 or 9 years of practicing here, both sitting as an arbitrator and appearing in arbitration hearings, I have not yet had one single case where rules have been adopted by parties. What typically happens is that the parties have a meeting, a conference with the arbitrator, and it's essentially a timeline that is going to be agreed. When do we submit our pleadings? When do we submit witness statements, and so on? So there are huge gaps, obviously, that are left by that. How do we deal with documentary disclosure, retifund process, and so on? The obvious way of overcoming that challenge is by adopting a set of rules. And that should be very easy. And in my view, it should be done at the earliest possible time, namely when the contract is entered and signed. If that is not done or hasn't happened, then I would encourage the parties to consider adopting one at the beginning of the arbitration process. And there are obviously any set of rules can be adopted as long as they are not against the public policy of Zimbabwe. So one could go for ICC rules or LCIA rules, for regional rules such as the AfCFTA rules, or now we have our domestic rules, which I also assisted in drafting, called the AIMA rules, which is the Africa Institute of Mediation and Arbitration, which is essentially the UNCITRAL arbitration rules adopted for sort of the Zimbabwean context. So there's a lot of rules to choose from. I would just encourage that one is chosen. A more sort of pervasive concern that one can have about rules and procedures in Zimbabwe is arbitrators typically take an extremely formalistic approach to arbitration processes, which is, of course, not the approach that is typically adopted in international settings, such as in English-seated arbitrations or Paris and so on. So at the moment, I've just been instructed in a matter this week where an arbitrator did not allow the leading of oral evidence at the final hearing because one of the parties did not put in an application notice duly supported by an affidavit. So that's just to demonstrate the sort of formalism that arbitrators sometimes require. Now, the way to manage that, and what I would typically do if I'm sitting as an arbitrator, is have a discussion about the level of formality that the parties and the tribunal wish to adopt, and have that discussion very early on. There's nothing wrong with a very formalistic approach as long as both parties and the tribunal know that that is the approach that is going to be followed. In the remaining sort of 1.5 minutes, I am just going to make 2 points about expert witness evidence in the Zimbabwean arbitration context, in the construction arbitration context. And the starting point is that it is inevitable that there are certain areas of expertise that are not covered by Zimbabwean experts. However, we have numerous jurisdictions around us, and South Africa is typically the one that we turn to and essentially import witnesses from there. So that is an issue that can be very easily overcome. The final point I would like to make about expert witnesses, and this is referring back to the point that I made already about how sophisticated the market itself is that I would encourage the legal representatives and the experts to be aware that the arbitrator may not be familiar with some of those concepts that perhaps people who are regularly engaged in construction arbitration are familiar with. And so the experts and the legal team should take the opportunity to essentially educate the arbitrator in those concepts and enable him or her or them to come up with an informed decision. Robert, I think that's all that my time allows me, so I will leave it there. Thank you very much.
Thank you very much, Dan. And now we go over to Tim Harwell, who is going to give us the HKA angle on things. Over to you, Tim.
Thanks, Robert. And thanks, Daniel. You actually finished off quite nicely on a point which I want to talk about, which is a positive trend which I've seen in South Africa, which is that arbitrators, albeit from a legal background, are becoming increasingly competent in some aspects of delay, quantum and engineering. However, there's always going to be some limitations to the technical proficiency of the arbitrator, and as projects become more complex, so do the nature of the disputes. And so there's always going to be that need for the expert role, which is not just to give an opinion, but it's also to demonstrate some technical competence by distilling out the key issues on which the key factual and contractual issues on which the expert opinions are based, and just not to overwhelm the arbitrator with analytics, which may result in the arbitrator overlooking or disregarding some of the important factual issues which are pertinent to the dispute and the reason the parties are in the dispute in the first place. Yeah, how can this confidence in the expert opinions be established with the arbitrator, particularly when the tribunal is faced with contrasting opinions from two opposing party-appointed experts? What I've seen in South Africa particularly, and also on another matter that I've been involved with in Botswana, is that the trend is for the increasing use of Scott schedules and joint reports, and also some more time being devoted to that in the arbitration timetable. Traditionally, these types of joint documents, Scott schedules, people commonly know of, are used for a side-by-side comparison on expert quantum calculations on disputes relating to variations or final account claims and the like. But in my view, they have a real solid application in other technical fields as well. For me, it's delay and disruption, and other engineering expert opinions can really benefit from going through that joint process where the experts get together, distill out and structure out what the key issues are, the foundations of their opinions, comment on each other, or provide a bit of a roadmap back to the previous submissions. And that has a benefit of injecting some clarity into the proceedings when there's often been exchange of various reports overlapping and perhaps an evolution of opinions throughout the submissions. Sometimes I also see the joint reports being requested from the outset of the expert submissions, where the experts are asked to get together, prepare a document which ensures that at least their opinions or the matters they give opinions on are consistent with each other. They're not got different instructions which don't speak to each other. And also there's, if possible, some level of agreement to the methodology that each expert, whether it be delay, quantum or engineering, which analysis methodology they're going to use to get to their opinions. And if the closer the experts can come from the outset, then more likely there's going to be something which is an end product which is going to assist the arbitrator or the tribunal, which is the role of the expert in the first instance. Traditionally, there's been some reluctance from the parties to allow experts to get together, a perceived lack of control. The experts might unnecessarily make concessions or negotiate things away. I've been involved in a matter in Botswana where the opposing expert came. I met with him, and he wanted to sort of negotiate some outcome with me, and it took some time to sort of get him on board. But that's not our role here. It's to narrow the issues, figure out what the important ones are and why. And so that's a perfect example of why parties are reluctant to allow experts to confer on these, traditionally on these types of issues. And also there's been reluctance from experts to meaningfully engage in the process, feeling like they're showing their cards, or and sometimes experts want to hide behind their previous reports and wholesale copy and paste previous reports or submissions into this joint report. So it's just as long, it's another big lengthy submission, and it doesn't really benefit the process. So in my opinion, that can be rather unhelpful. But despite this reluctance from the parties and experts, I think that I do see the trend that more periods of time have been devoted to that. This in arbitration timetables. The benefits for the tribunal are clear. They get a document which is a bit of a roadmap to how to navigate all the submissions for some of the technical issues. For the experts, it allows someone like myself to take a step back. Often you've developed a report or an opinion in isolation over many months or years. You get to really test that, take a bit of a stance, and then contrast it to the opposing expert's opinion, test what the key factual, contractual assumptions as well, which underpin the report. And so it's a way of preparing yourself for what's going to come when you give oral evidence. And therefore, for the parties, the benefit's also clear. You're going to get an expert who's already somewhat tested the opinions which has been offered, and also ensure that the key factual issues which you've gone to dispute on don't get missed or overlooked by the time we get to the hearing. So one final note as well, that the structure of the document's important, and there's not necessarily a one-size-fits-all to a joint document. And one very final point is that I'd say that on the topic of dealing with expert witnesses, traditionally they've been dealt with a healthy skepticism, which is quite rightly so. There's probably, I've seen other experts in operation who appear to be championing a cause of their party, and so that's probably given a perception to arbitrators out there that experts should be treated with caution. However, I think this joint document process is one good step in the direction of putting those concerns aside and making sure that experts are really doing their job, which is to assist the tribunal. Thank you, Robert.
Thank you very much, Tim. Well, now we've come to the end of presentations, but 8 different questions have come in while you've all been speaking. And there's a common theme coming through, which is a concern about how supportive the various national courts are to the procedures that you've been talking about, the adjudication, the arbitration, expert witnessing, and so on, and expert determinations and so on, because those are all outside of court, but they do periodically find themselves in court. For example, you want to enforce an adjudication, you have to go to court. You've got an arbitration clause, but one party starts proceedings in court nevertheless. How do you get the dispute moved back to arbitration? And so on. So the overall question that's coming out is, to what extent are regional courts supportive of these non-court procedures? So we've got expertise now from South Africa, Zambia, Zimbabwe, and so on. So a wealth of expertise. Would someone start with the South African?
I would like to volunteer, actually, an answer.
Okay.
Please, if you don't mind.
Virginie?
Because I had a very recent experience in relation to an arbitration in Nigeria, where the Nigerian court has issued an injunction court order against the members of the tribunal who was sitting in London. And this is, has been the result of an anti-suit injunction court order that my client has obtained from the English courts against this interference from a Nigerian court. I mean, the Nigerian courts were interpelled by the Nigerian party, who was trying to frustrate, in fact, the international arbitration. This was not just one attempt, and there have been a lot of attempts of the same kind. But this is an example of where actually the courts can either help or actually frustrate the resolution of a dispute. So, and then there is a fight, in fact, between jurisdictions about how to resolve these kind of disruptions. So I thought it was useful.
Right, I see Dan's got his hand up.
I do. If I may answer that from the Zimbabwean perspective, and of course, I think the question is a very valid one, because no arbitration exists in a vacuum, which is exactly why I started with the statutory framework. Arbitration by its very nature will always be reliant on the support of the court system. So far as Zimbabwe is concerned, because it is a model law country, the major interaction between the tribunal and the court system is either Article 34 when you're applying to set aside an award on the very limited basis that are permitted, or Article 35 when you are trying to enforce a domestic or an international award, and the other party can object to that, again, on very limited grounds. So far as Zimbabwe is concerned, I will nail my colors to the mast. I think the courts have not yet got the idea of arbitration. And there is, courts do not hold back here. And you will very, very often be in front of a high court judge who will simply say, well, Advocate Tivador, I would not have reached this decision that the tribunal reached. How can it be in accordance with the public policy of Zimbabwe that we enforce an award that I would not have made? And then, of course, you're back to square one. So in my view, those concerns that Abdul raised right at the beginning in his introduction to arbitration as a topic are very, they very much apply in the Zimbabwean context. And I think there's a lot more kind of development, learning, and trust that is yet to be done.
Thank you. Abdul, I see your hands up.
Thank you, Robert. If I may defend the honor of my country for a minute. I think what one has across the continent is you have different sophistications and jurisdictions, and that applies within countries. So taking Nigeria as an example, Nigeria is a federal system, and it depends on which state you go to as to the level of sophistication you get with the judiciary and the familiarization with arbitration. So paradoxically, Lagos State, which is the commercial capital, the judges there are very familiar with arbitration, they get trained in arbitration, and they're very good with arbitration. When you go to the federal level, it tends to be less so. And you go to other states, you have people who are absolutely totally non-familiar with arbitration. So it's not, I think we'll have to be very careful about generalizing about jurisdictions on the continent. Some jurisdictions get arbitration and are very good and very proactive in supporting arbitration. Other jurisdictions, much less so.
Thank you very much, Abdul. And that brings us to the conclusion of our part. But now we move to Dr. Ademola Bamgozi, who is the ACL Director of Strategy and Operations, and he's going to make some closing remarks. So over to you.
Thank you so much, Robert. Unfortunately, we've come to the end of what I found to be a very fascinating and interesting event. And my first task this afternoon is to, on behalf of Africa Construction Law, thank everyone who has contributed to the success of this event. I was speaking with my colleagues at ACL yesterday afternoon, and we had very high expectations of this event. Well, I must confess that what I have witnessed this afternoon exceeded all our expectations. It was clear that each speaker put a lot of thought and work into their presentation. They brought their wealth of experience and knowledge, and there was so much to learn from each and every speaker. Now, so to Keaton Chambers, to HK, to Allen and Overy, to Musa Dudhaya and Co, and to Kiran and Musanda Associates, we can't thank you enough. Thank you for putting together such a successful event. Thank you for contributing to capacity building in Africa. I know a lot of billable hours and resources have gone into putting this successful event together, and we do not even take it for granted at all. I must also say a special thank you to the business development department in the organizing and collaborating organizations. We couldn't have achieved this without you. To the delegates and to everyone who has joined this event, thank you for joining us and for actively participating by sending in questions and many comments. Unfortunately, we've not had the time to go through all your questions, but you would agree with me that it's been a very good session. All our efforts and preparations would have been in vain without your decision to join, participate, and actively engage with the speakers. It would have been sad to have seen such a rich content and excellent lineup of speakers and not have the audience to present the content to. So thank you for joining this event. We would in due course make the recordings and slides from this event and other sub-regional sessions available on our website at www.africaconstructionlaw.org. Please visit our website to access the rich content we would upload. And like I mentioned, I know we've not been able to deal with every question. So if you still have questions that have not been answered, please send them to info@africaconstructionlaw.org. Or, maybe email speakers individually. Maybe some of them would have the time to respond to you. One thing to flag as I conclude is that this event is the first of many others to come. Indeed, we have a number of programs in the pipeline which you definitely do not want to miss. For example, we're in the process of finalizing a project which highlights the construction law and practice in over 20 jurisdictions. You can imagine the amount of content that is there. We're also finalizing alliances and collaborations with leading institutions across the globe. So there's so much to enjoy and benefit from. The only way to know about these opportunities and to benefit from these opportunities as soon as they're released to the public is by following us. So go on our website, please complete the membership forms, go on our social media pages, LinkedIn and Twitter, and just follow us there. Our existing members come from all sectors of the construction industry. We have lawyers, architects, engineers, surveyors, contractors, developers, and so on. So by signing up as a member, you be kept abreast of latest events and publications by ACL. What are you waiting for? Go and join now. Anyway, I've done a lot of talking and I know you are tired of listening to my voice. So I would say thank you very much for joining again and have a great evening.